am extraordinarily proud and privileged to introduce to you Professor Linda Silberman of NYU Law School. I'm just going to say a few words about Professor Silberman's credentials. I obviously cannot read them all. It would take the entire time that we need for the lecture. But let me just say a few things. Professor Silberman is a legendary, iconic professor at NYU. She was the first woman to be tenured at NYU, and one of the first to be tenured in a top 10 law school in the United States of America. So just an iconic, historic, important figure. She is a graduate of the University of Michigan and the University of Michigan Law School. And following graduation, a Fulbright scholar in London, England, she joined NYU faculty in 1971. As I said, became the first tenured woman full professor at the school. Professor Silberman teaches and writes in the areas of conflicts of law, civil procedure, comparative civil procedure, transnational litigation, of course, international commercial arbitration, and international family law. Prior to joining NYU, the NYU faculty, Professor Silberman practiced with the Sonnenschein, Knapp, and Rosenthal law firm in Chicago, Illinois. In 1985-86, she was professor in residence at the U.S. Department of Justice. She held a visiting professorship at Harvard, Columbia, and the University of Pennsylvania law schools. Professor Silberman has been a member of numerous U.S. State Department delegations to the Hague Conference on Private International Law, and is presently a member of the State Department Advisory Committee on Private International Law. She is also a member of the Singapore Family Justice Court's International Advisory Council, a member of the Academic Council of the Institute of Transnational Arbitration, a board member of the Institute of Judicial Administration, and a fellow of the American Bar Foundation. Professor Silberman has been invited to gave the general course, on private international law at the Hague Academy of International Law in 2020, and I can reaffirm, based on personal knowledge and hearsay as well, so every form of knowledge, direct and indirect, that it was a smashing success. She is co-author of a leading civil procedure case book, Silberman, Stein, and Wolf, now in its 5th edition, also a remarkable textbook. I went out of my way to make sure I had an exemplar autographed by the professor, as well as a book on comparative civil procedure, civil litigation, and comparative context, 2nd edition. It came out, I think, in 2017. Professor Silberman has played an important role at the American Law Institute, the ALI, of course, serving as an advisor on 3 different projects. You know, 1 or 2 projects just simply was not enough. The Restatement 3rd of the U.S. Law of International Commercial Arbitration, the Restatement 4th of the Foreign Relations Law of the U.S., and the Restatement 3rd of Conflicts of Law. Previously, she was co-reporter of a recently completed project of the American Law Institute, Recognition and Enforcement of Foreign Judgments, Analysis, and Proposed Federal Statutes. I can go on for the rest of the time we have, but I can't and won't. So without any more delays, Professor Silberman, thank you so much for joining us. It is a privilege, a pleasure, and a distinction. The floor is yours, Professor.
Thank you, Pedro. It's a privilege, actually, to do anything with which you are involved. And I say that from the bottom of my heart. All of those accolades you mentioned just come from being old. So at the end of the day, I just hope this is a talk that will interest you and will solicit your questions at maybe some point in the future. The topic of my talk today involves an issue with which I know you've dealt with in your practices, and that's the approach that national courts take to the recognition and enforcement of a New York or Panama Convention arbitral award that has been set aside at the seat of arbitration. So my plan is to highlight the different approaches to that question in various countries. But I thought, to make it a little different, I would set these developments in the context of some recent criticism directed at the Hague Conference's Choice of Court Convention, known as COCA, by Gary Bourne. So the Bourne critique of the Choice of Court Convention. Gary has written a paper in the Penn Law Review and posted an extensive blog on the Kluwer Arbitration blog, which I'm sure many of you have seen. And he argues that U.S. ratification of the Choice of Court Convention would expose litigants to risks of procedural unfairness or corrupt adjudicative processes, notwithstanding the choice by the parties to have their dispute litigated in that particular court. The choice of court convention, which requires contracting states to respect the party's choice of a forum, a court, and to recognize and enforce the resulting judgment, does not include an express provision that would permit a contracting state to refuse to respect such a judgment because the overall legal system is viewed as corrupt or biased. The non-recognition exception for public policy that is provided for in the choice of court convention states that recognition or enforcement may be refused when it would be manifestly incompatible with the public policy of the requested state, including situations where the specific proceedings leading to the judgment were incompatible with fundamental principles of procedural fairness of that state. So more specifically, Bourne argues that there are a substantial number of national courts that are unsuitable for resolving international commercial disputes due to their serious compromise of the basic standards of integrity, independence, and competence throughout their judicial system. And he posits that the convention provision that references specific proceedings rather than the judicial system as a whole does not encompass a defense that the entire judicial system is unfair, biased, or corrupt if you can't make a showing about the specific proceeding. And moreover, unlike the very recent 2019 Judgments Convention, there is no provision in the choice of court convention that permits a contracting state upon ratification to reject a treaty relationship between itself and another contracting state. As a result, Bourne makes the argument that the choice of court convention should not be ratified by the United States, given the failure to deal expressly with systemic flaws that exist in some judicial regimes. So I'm interested in whether the Bourne critique has any application to arbitration and awards set aside at the seat. So the Bourne critique brings to mind a potential similar concern with respect to international arbitral awards and the possibility of a set aside by a national court at the seat or the place whose arbitration law is chosen. Now, I use the term seat as a shorthand for the competent authority, and I use the term set aside and annulment sort of interchangeably. An award by an arbitral tribunal, of course, does have the advantage of its independence from any national court, but that award can still be set aside by a national court at the seat pursuant to national law. Indeed, the national court at the seat, or that place, is potentially subject to the same charge of parochialism and bias that Bourne makes in the context of the choice of court convention, particularly when one of the parties to the award is a national, often a state entity of that country. Since one of the grounds for non-recognition of a New York or Panama Convention award is that the award has been set aside at the seat or competent authority, the approach that a country takes to the treatment of set-asides raises some of the same concerns that Bourne has emphasized with respect to a court chosen through a forum selection clause. So I'm curious about your reactions to this comparison. Now, I turn now to the Article 5.1e defense to recognition and enforcement of an award. Another point about nomenclature before I start. The New York Convention uses the term recognition and enforcement of the award in referring to the defenses to an arbitral award. The Panama Convention in that context uses the term recognition and execution of the decision. Chapter 2 of the Federal Arbitration Act that implements the New York Convention uses the term confirm the award rather than recognize or enforce the award. So in the talk, I'll use the term recognition or enforcement rather than confirmation as much as I can, but US courts often refer to confirmation of the award. So consider these terms sort of interchangeable as I speak. Article 5.1e does not compel non-recognition in an arbitral award that is set aside at the seat or the place under the law of which the award was made, nor does it dictate recognition of that set-aside judgment. Article 5.1e provides only that recognition and enforcement of the award may be refused at the request of the party against whom it is invoked if the award has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. Indeed, Article 7 of the New York Convention allows a party to avail itself of an arbitral award in the manner and to the extent permitted by the law or treaties of the enforcing state, thereby providing an alternative route for recognition of the award under that country's national law. So national courts are free to continue to recognize and enforce an award set aside at the seat, and the approach to an arbitral award set aside there rests on national law. So I'm prompted now to survey the approaches that different national systems accord to such set-asides in assessing whether the Bourne critique also has application in the arbitration context. Let me talk a little bit about these national approaches. Only a very few states give no weight at all to a set-aside at the place of arbitration. Most notable is the approach of the French courts, which take a very strong pro-arbitration and a negative attitude towards set-asides. In France, international arbitration is viewed as part of a transnational legal order, unattached to the national legal regime. And to that end, the French legislation implementing the New York Convention has eliminated the Article 5.
Excuse me, Professor, I think you've gone on mute. I think your system is muted.
Hold on a second.
Oh, you're back.
Okay, I don't know what happened. How long has it been?
Just about 20 seconds.
Okay, so let me, I don't know, I didn't touch anything. It said someone else muted
No,
me.
I think it was on our end. So it's 15 words ago, Professor.
All right, so I'll just talk about the French legislation, which eliminated Article 5.1e, which I know you all know, and they rely on Article 7 of the New York Convention. In two modern cases, the Hill-Martin and the Poutabali case, the French Cour de Cassation enforced awards notwithstanding a set-aside at the place of arbitration. And Hill-Martin, an initial award in favor of the French defendant and denying recovery to the English plaintiff, was set aside in Switzerland. Nonetheless, the French courts enforced the award. But interestingly, a second Swiss award in favor of the plaintiff was later denied enforcement in France on res judicata grounds, but then the award was subsequently enforced in England. So this is not a great solution. Courts in other countries take a diametrically opposite approach to a set-aside and view the award as inextricably linked to the legal regime at the seat of arbitration. This territorial approach, ex nihilo nihil fit, out of nothing comes nothing, is justified in various ways. As a matter of party autonomy, the territorial approach views the choice of a seat as a submission to the authority of a given state, and part and parcel of that choice is acceptance of the supervisory authority of the courts at the seat. The starting point is that the state has a monopoly on the legitimate adjudication of rights and liabilities through the court system it establishes in its territory. And insofar as privately appointed arbitrators are authorized to assume the function of adjudicators, those arbitrators function only with the blessing of the state. In essence, arbitration operates pursuant to a jurisdictional delegation of the state's adjudicatory authority. Moreover, parties who agree to arbitration in a particular jurisdiction are aware of the potential consequences. They are choosing the seat and the legal regime of arbitration established in that country, and therefore should not be heard to complain. In that sense, the concern advanced by Bourne about potential parochialism of national courts seems relevant in the context of international arbitration. And a number of civil law countries like Germany, Chile, Brazil, and Russia do not enforce arbitral awards set aside at the seat. German courts, for example, look to the award status in the country where it's made without engaging in any scrutiny of the annulment decision itself. And German law goes even further to provide that a court may even reverse an earlier decision of recognition and enforcement if it's later set aside at the seat. So neither the enforce all nor enforce nothing approach is without difficulty. However, a middle path that would leave the issue to the discretion of the recognizing court has the disadvantage that it provides no guidance or uniformity. One alternative, endorsed by some arbitration experts, is that awards that are set aside should only be recognized and enforced when the grounds for the annulment are those set forth in the New York Convention. Such an approach necessarily embraces concerns about idiosyncratic or parochial grounds for set-asides, since it would ignore set-aside based on non-convention recognition grounds and permit the award to be enforced elsewhere. In effect, such a set-aside would have only local and not international effect. The earlier European Convention of Arbitration of 1961 included such a provision, but the New York Convention rejected that solution. So to adopt that rule for New York Convention awards would be to ignore the fact that the New York Convention decided against it and is silent on the matter. Such a requirement also seems extreme if one considers it, for example, in some cases, parties have agreed to arbitration in a place where, let's say, substantive legal review is part of the arbitral regime. In such a case, annulment on that basis would seem to be appropriate. A somewhat cynical alternative was suggested by the late Professor Hans Smith, who argued that all set-asides should be presumptively disregarded in situations where the set-aside takes place in the home court of one of the parties and at that party's request. Now, Professor Smith's position reflects a pragmatic realization that local bias and parochialism at the place of arbitration often affects the set-aside decision, particularly when a state-owned entity is concerned, and where is often the case, the state somehow itself had required that arbitration with that enterprise be seated in that state. Nonetheless, that approach is strikingly over-inclusive. So, what's the approach to recognition of set-asides in the United States? Other countries, including the United States, have attempted to carve out a different middle path, although the precise standard that courts are applying is not always clear. In Baker Marine versus Chevron, the Court of Appeals for the Second Circuit stated that it would enforce an annulled award only if there were adequate reasons for refusing to recognize the set-aside judgment of the court at the seat, and it concluded that this was not the case on the facts before it. In the Termarillo versus Electricanta case, the Court of Appeals for the District of Columbia appeared to set a higher threshold for a refusal to respect the Colombian set-aside judgment of an award rendered in Colombia. The ground for the set-aside was that the arbitration clause selecting ICC rules was a violation of Colombian law. The DC Court of Appeals stated that a foreign set-aside judgment should be respected absent extraordinary circumstances, and emphasized the narrowness of any public policy exception in that context. And the court there distinguished an earlier DC District Court case, the Chromalloy case, which did enforce an award that had been set aside at the seat. But the reasoning in that case was heavily criticized, and that case settled before any appeal was taken. So in 2016, the Court of Appeals for the Second Circuit became the first U.S. federal appellate court to confirm a foreign convention award had been set aside at the seat. The case, Corporación Mexicana versus Pemex, I'll use the term Pemex throughout, involved an ICC arbitration seated in Mexico. An award of $300 million in damages was rendered in favor of Camisa, a Mexican subsidiary of KBR, which was a US corporation, against the Mexican state-owned petroleum company, Pemex. Camisa sought to enforce the award in New York, while Pemex moved to set aside the award in Mexico and to stay the New York proceedings. The US District Court denied the stay and confirmed the award. While the case was on appeal to the Second Circuit Court of Appeals, the Mexican court, the 11th Collegial Court, annulled the award on the ground that the dispute was non-arbitral under Mexican law. Relying on both a recent Mexican law, as well as an earlier 1994 judgment of the Mexican Supreme Court. And they said it was against Mexican public policy, the award. As the result of annulment, the U.S. Court of Appeals sent the case back to the district court for consideration in light of the Mexican set-aside. The district court followed its initial decision, recognizing the award and declining to defer to the Mexican's court ruling, which it found to have violated basic notions of justice by impermissibly applying the Mexican law retroactively, and that it had left the plaintiff with no remedy. The U.S. Court of Appeals affirmed the district court, writing an opinion that conceivably set a new framework for considering the effect of a set-aside on the recognition of an arbitral award. The Second Circuit did not stop the standard suggested by the panel in Baker Marine, that recognition of an award set aside is inappropriate absent an adequate reason, nor did it demand the high threshold of extraordinary circumstances that the Termarillo case referenced. Instead, it framed its analysis in terms of comity, with specific reference to US law on the recognition of judgments. The Court of Appeals began by describing the district court decision to enforce an award despite the set-aside as a potential denial of comity to the Mexican judgment, a formulation that the district court itself had never used. Nonetheless, the Second Circuit affirmed the district court's recognition of the award and the resulting non-recognition of the Mexican judgment. The court explained that although foreign judgments are generally conclusive as a matter of comity, there is an exception where recognition and enforcement of that judgment would offend the public policy of the state in which enforcement is sought. As to the content of public policy, the Court of Appeals relied on a prior decision in a more traditional recognition of judgments case that held a judgment is enforceable as against public policy to the extent that it's repugnant to fundamental notions of what is decent and just in the state where enforcement is sought. The Court of Appeals noted that the standard is high and infrequently met, and only a judgment then tends clearly to undermine the public interest, the public confidence in the administration of the law, or security for individual rights is against public policy. Notwithstanding this high bar to ignore the set-aside judgment, the Court of Appeals determined that the district court was correct in finding that the Mexican set-aside judgment contravened US public policy in applying the Mexican law retroactively and leaving the plaintiff without a forum. Curiously, in affirming the district court, the Court of Appeals stated that in reviewing a district court's decision to extend or deny comity to a foreign proceeding, it would apply an abuse of discretion standard. That standard of judicial review is not one that was applied by appellate courts in either Termarillo or Baker Marine. It's true that in both of those cases, it was said that a US court had only a narrow discretion to confirm an award that was set aside by a competent court. But the discretion referenced there was about the discretion inherent in the may refuse language of the New York and Panama Convention, and was directed to the discretion that each contracting state has in determining how to deal with the set-aside. It did not and should not, in my view, pertain to the allocation of decision-making between the district court and the appellate courts in the US system. I now turn to a subsequent decision of the Second Circuit Court of Appeals, the Tai Lau Lignite versus Laos case, which I think highlights the need for further criteria to guide a court in the United States in evaluating a set-aside of a foreign convention award if a judgments framework adopted in PEMEX is to be at all workable. Tai Lau involved an arbitration in Malaysia resulting from an agreement between Tai Lau, a Tai Lau company along with its Laotian subsidiary, and the government of Laos, whereby Tai Lau was granted the right to mine lignite coal and to build a power plant in Laos. The Laos government terminated the agreement, and the Tai Lau companies commenced an arbitration in Malaysia pursuant to the agreement. The result of the arbitration was a $57 million award in favor of the Thai companies. After the period for challenging the award in Malaysia had expired, the Thai company brought enforcement actions in the United Kingdom, in France, and in the United States. In the United States, the district court confirmed the award, and the Second Circuit affirmed that decision. The UK court also rendered a judgment during enforcing the award. However, during these proceedings, the government of Laos managed to obtain an extension of time from a Malaysian appellate court in order to challenge the award, and the Malaysian court eventually set aside the award on the ground that the arbitrators had exceeded their jurisdiction by deciding disputes arising from contracts that predated the project agreement. At that point, the government of Laos sought to reopen the US proceedings, including the Court of Appeals decision that had confirmed the award, and the government was successful in doing that. The US District Court vacated its earlier confirmation of the award and, pursuant to Article 5(1)(e), refused to enforce the award. And the District Court also refused to enforce the English judgment that had also enforced the award prior to the time it had been aside. As to the Malaysian set-aside, the District Court distinguished the Malaysian set-aside from the Mexican set-aside in Pemex. Unlike in Pemex, the ground for set-aside in the Malaysian proceeding was the universally recognized ground of excess of jurisdiction. And because the Malaysian court had ordered re-arbitration before a different panel, the plaintiff had not been left without a remedy. On appeal, the Second Circuit affirmed the District Court's refusal to recognize the award, and implying Article 5(1)(e), the Court of Appeals referenced the earlier judgments approach it had adopted in Pemex and reiterated the view that a foreign judgment is unenforceable against public policy only if it is repugnant to the fundamental notions of what is decent and just in the United States. The Court of Appeals emphasized that even if it might not agree with the merits of the Malaysian court's judgments, such disagreement did not rise to the threshold of a public policy concern. I want to briefly address what may appear to be an inconsistency of the outcomes of Pemex and Tai Lao. As I've already pointed out, the grounds for the set-aside in the respective cases were quite different. In Tai Lao, the ground for set-aside was one that's internationally accepted, that the tribunal had exceeded its jurisdiction by extending the agreement to reach non-parties and claims related to other contracts. In Pemex, the set-aside ground, although characterized as one about non-arbitrability, can nonetheless be seen as a parochial and idiosyncratic local annulment and one designed to favor a state entity. Moreover, unlike the decision in Pemex, which appeared at least to leave the plaintiff without a remedy, the Malaysian Tai Lao ruling had ordered a second arbitration. So the judgments approach reflected in Pemex and Tai Lao has also been endorsed in the new American law restatement of US law on international commercial and investor state arbitration, which should be coming out soon. The relevant black letter provides that even if a convention award has been set aside by a competent authority, a court of the United States may recognize or enforce the award if the judgment setting it aside is not entitled to recognition under the principles governing the recognition of judgments in the court or in other extraordinary circumstances. The latter category of extraordinary circumstances is explained as an attempt to account for possible lacuna in the law of judgments that might allow for recognition of particular judgments that are highly troubling. However, the law of judgments as set forth in the fourth restatement of foreign relations law includes defenses to recognition and enforcement based on failures of impartial tribunals and fair procedures in the foreign judicial system as a whole, as well as in specific proceedings. It also provides a defense where the judgment was rendered in circumstances that raise substantial doubt about the integrity of the rendering court with respect to the judgment. US law also provides exceptions to recognition and enforcement of foreign judgments based on fraud, lack of notice, and public policy. So it's not clear to me what is left to include in the exception for extraordinary circumstances once US law on foreign judgment recognition is actually invoked. But this judgment's approach to set aside is not without its critics. Among the objections are that the approach is superfluous when the set aside is not rendered at the primary jurisdiction, and it's vague and unhelpful in other situations when it does matter, that it does nothing to establish international recognition and enforcement standards for awards, and that it is at odds with the text of the convention. Now, because I wrote an article some years ago advocating an approach to set aside that urged US courts to treat set-asides as they do foreign judgments, I want to offer a brief response to those critiques. At the same time, I recognize the need for better guidance if this judgment approach is ultimately to prove workable. So first, I'm going to address the criticisms to this judgments framework, and then I want to discuss a more recent Second Circuit decision that adds yet another complication as to how courts are to approach this comity standard with respect to a set-aside judgment. First, a response to the critics. So it's true that a judgments approach is unnecessary where the set-aside occurs at a place other than the seat or the place under the law of which the award was made, because the convention themselves do not authorize an exception to recognition and enforcement of the award in such a case. And so non-recognition of a set-aside in that situation doesn't provoke much debate. Still, I agree that the content of this judgment recognition principle must be clarified to be helpful, and I'll turn to that when I discuss the most recent US appellate case. As for concerns about the failure to provide international standards for cases that matter most, there's never going to be any harmonization or consistency in the approach to the awards that are set aside by a competent authority, unless there is a binding protocol on how to deal with the problem of annulled awards. Admittedly, the judgments approach is based on the national law on the recognition of judgments, and that's something in each contracting state, and therefore ostensibly lacks international uniformity. Nonetheless, a comparative look at recognition and enforcement practices across jurisdictions reveals a basic similarity of approaches and generally agreed upon criteria. And I just note that both the Dutch and English courts have embraced such an approach to set-asides that relies on their country's law of judgments in assessing the effect of a set-aside. Certainly a judgment solution is less vague than the mere discretion that appears to be the alternative, and a judgments framework does provide certain identifiable principles to determine when a set-aside should be recognized. Finally, I do not think that a judgments approach is at odds with the text of the convention. The convention is silent on the method for determining when an annulled award should or should not be enforced. Indeed, a comity standard with guidelines based on recognition of judgments, law, or practice arguably does the least violence to the wording of the conventions, which uses the word may. The alternative all or nothing approaches I discussed earlier transform the language of may refuse to recognize into a must or must not recognize the award. And in comparison to such alternatives as fishy, a standard proposed by my good friend and late colleague, Andreas Lowenfeld, the judgment framework is principled and sufficiently familiar to recognizing courts such that it's likely to achieve a satisfactory level of certainty and predictability. Nonetheless, even in the US, this new judgments framework was going to require elaboration. In the most recent decision from the Second Circuit in July of this year, the Esso Exploration versus Nigerian National Petroleum Corporation is illustrative. Esso involved an application for confirmation of an award of $2.7 billion rendered against Nigerian state-owned petroleum company NNPC by an arbitral panel in Nigeria. That award was subsequently set aside in part by the Nigerian courts. The underlying dispute concerned the allocation of oil pursuant to a production sharing agreement between Nigerian subsidiaries of Exxon, which was Esso Nigeria, and Royal Dutch Shell, which was Shell Nigeria. Although the arbitral tribunal had rejected NNPC's argument that the dispute involved a tax matter and was not arbitrable under Nigerian law, a Nigerian court set aside the award on precisely that ground. The Nigerian Court of Appeal, in two separate judgments, later reinstated certain non-monetary aspects of the award, concluding that NNPC had breached the agreement, but it declined to reinstate any damages portion of the award, which it said actually involved tax liability. Now, multiple appeals remained pending in Nigeria when Esso brought its petition to confirm the entire award in New York. The US District Court, relying on the judgment's approach in Pemex and the criteria the Second Circuit considered there, refused to enforce the award on the basis of the Nigerian set-aside. On appeal, the Second Circuit affirmed the lower court's refusal to enforce a part of the award relating to taxes that had been set aside by the Nigerian courts. However, the Second Circuit found that the district court had gone too far in refusing to enforce the entire award. It remanded the case for the district court to consider just what part of the damage award, if any, had not been set aside in Nigeria. And I understand now that that case has actually been settled. But more critical for my purposes is the assessment of the Second Circuit's application of its comity standard to the recognition of a set-aside judgment. The district court had restricted its analysis to the 4 considerations that the Second Circuit had identified in the earlier Pemex case, included the importance of upholding contracts, the repugnancy of retroactive legislation, the need to have a forum, and the concerns about government expropriation without compensation. And it concluded that in evaluating these factors, the Nigerian set-aside was entitled to comity and should be respected. Although affirming the district court's decision, the Court of Appeals emphasized that the district court should not have limited its inquiry to the 4 Pemex considerations, saying the Pemex analysis did not reduce the applicable standard to a 4-factor formula that courts must or necessarily even should apply in every case involving set-aside of arbitral awards. In ESSO, the Second Circuit, however, did not clearly identify what other factors a court should consider, although it referenced Pemex as looking to the established standards in US courts to declining to enforce foreign judgments. And the Court of Appeals cited to the restatement 4th of Foreign Relations Law of the United States, which, as I mentioned earlier, listed these elaborate grounds of both mandatory and discretionary grounds for non-recognition of a judgment. The Court of Appeals in ESSO appeared willing to question that set-aside court's substantive conclusions, but cautioned that it would do so only so far as it is required to ascertain whether they are plainly incompatible with US notions of justice. On that point, the Court of Appeals observed that the Nigerian court's judgments relied on Nigerian law and that the relevant issues were rationally analyzed by the courts. And the Second Circuit said it was not its role to engage in a more probing analysis of the Nigerian court's judgments. The court also entertained ESSO's assertions that the Nigerian court proceedings were fundamentally unfair, but it rejected those arguments based on both process and sort of substance grounds. As to the fairness accorded ESSO in the Nigerian courts, the Court of Appeals found that ESSO had adequate opportunity to be heard and that their arguments were considered in Nigeria, which resulted in a partially reinstated award. On substance, the Court of Appeals also rejected ESSO's argument that had been supported by declaration from experts that the Nigerian judiciary was incapable of providing ESSO with an impartial tribunal because they generally disadvantaged international organizations seeking to hold the state liable. The Court of Appeals pointed to other evidence of Nigerian decisions ruling against NNMPC and other Nigerian state entities. But the ESSO case does highlight how difficult it is to actually apply this comity judgments framework to assess a set-aside. And the case raises the question about how much scrutiny an enforcing court should give to a set-aside judgment before rejecting it. But it does seem that the criteria for assessing recognition and enforcement of a foreign judgment, including the public policy exception, leaves room for a court to assess the quality of the judicial system and the fairness of the procedure, both systemically and in regard to the specific proceeding, with respect to a set-aside of an arbitral award in the arbitration context. And as to Gary Bourne's critique of the choice of court convention that I started my talk with, I think the same can be said about a judgment rendered pursuant to a choice of court convention. I believe that the public policy exception found in the choice of court convention is in fact broad enough to address the systemic failures of certain judiciaries that Gary is so concerned about. So I leave it to you to think about this comparison, and I would be happy to take questions either now or later.
Professor, first and foremost, thank you so much. Very, very helpful, clear, and I think extremely provocative. You know, we are working on, part of the team here is working on a $388 million enforcement issue. So we're